one of Nigeria's most controversial police officers that has scored a legal victory. A federal high court in Abuja has discharged and acquitted suspended Deputy Commissioner of Police Abba Kyari and brothers in a case involving alleged non-declaration of assets brought by the National Drug Law Enforcement Agency. The prosecution had filed 23 counts, alleging that Kyari and members of his family failed to properly declare properties and concealed the origin of certain assets. But the court ruled that the prosecution failed to establish the allegations, effectively ending the case.
However, this is not the end of Abba Kyari's legal troubles. The NDLEA has clarified that the drug trafficking case linked to an international cocaine syndicate remains active in court, meaning the suspended police officer is still facing serious legal scrutiny. So what does this acquittal, I beg your pardon, mean legally? Was the prosecution weak, or did the defense simply dismantle the case? Well, joining us now to break down the legal implications is Evans Ufeli. He's a legal practitioner. Thank you very much for joining us this morning, Evans Ufeli.
Thank you.
Grand. Evans, let's start by understanding the scope here. When they say someone has been discharged and acquitted, what exactly does it mean? What are the fundamentals here? Discharged and acquitted.
Yes, when they say a person has been discharged and acquitted, what it means is that the prosecution is unable to prove the guilt of the defendant. And so because it's unable to prove the guilt, the court has hereby let him loose, let him go, because in criminal prosecution, it is proved beyond reasonable doubt. The onus is on the prosecution to prove that the defendant actually committed the offenses so preferred in the charge sheet. Where the prosecution, and that onus, that burden on the prosecution does not shift. You know, the prosecution will have to rely on the strength of his own case to prove or inculpate the defendant. And that will be by evidence. See, because it's not enough when arrests are made and the publications are made in the newspaper and all over the place that someone has committed the following offenses and they have been, according to them, they've concluded investigation and they've rolled out charges, multiple charges, in this case 23. Each of those charges must be proven beyond reasonable doubt. Okay. So where any of them is unproven, that charge will fail against the defendant. And that's how to run through down. If the prosecution is unable to prove any, then it means that the defendant did not commit the offense. Okay?
Okay.
I mean, for want of evidence, the defendant cannot be convicted or be found guilty of the offense for which he's so charged.
Okay, then, Evans.
So to be discharged and acquitted means the defendant has been freed of all count charges preferred against him.
Okay, so Evans, it doesn't mean that there is no allegation against him. It just simply means that, well, tell us exactly what it means. Does it mean that the prosecution delivered a presented weak evidence? Is that what it means?
Yes, the prosecution's evidence could not inculpate the defendant. When you look at it, you see that the issue of asset declaration, when they presented it before the court, they were unable to prove ownership of the properties. Okay, you have to prove ownership of the property, that truly the defendant owned the properties. Okay, and you have to prove that by documentations. Okay, how can you establish that a person owned a property under the Nigerian law? There must be documentation to that effect. And the defendant had said that, you know, the properties were inherited properties from his late father. And when you look at that failed. Then on the issue of conspiracy, okay, which was also part of the charges leveled against him, conspiracy with his brothers and the rest of that, the prosecution still was unable to prove that. And so at the end of the day, what you have is that the charges were knocked off. Okay. The prosecution at all times is expected under the law to prove his case beyond reasonable doubt. When it's unable to do that, then it falls flat on its face, and then the defendant cannot be convicted.
All right then, Evans.
Now, when we look at the case, it said there that it was a 23-count charge involving asset declaration issues. In cases like this, what kind of evidence would the prosecution normally need to prove such allegations beyond any reasonable doubt?
Yeah, for each count charge, if you say that Mr. A took the belongings of Mr. B, okay, that's one count charge. Then second count charge is Mr. B conspired, Mr. A conspired with Mr. B and did that as a second count charge and all that round. The first count charge, you have to, as a prosecution, you have to call witnesses. In the absence of witnesses, you have to present documentation. You have to present evidence to establish, to strengthen your argument. Because you cannot just come to court and say, Mr. A stole from Mr. B. Now, you don't have the item that was stolen. You don't have an eyewitness. You don't have any either photographic evidence or whatsoever. You are just saying that he stole. Where's the item stolen? When did he steal this? At where? So, you see, all this where, when, how, and all that, coupled with evidence or witnesses or whatsoever, once, in the absence of all that, it means the defendant didn't do what you say he did. So, the evidence that is required vary from cases to cases and the nature of the accusation or allegation before the defendant. Okay? So, but the bottom line is that it's not enough to say that a person committed an offense. Because in criminal prosecution, once doubt is created in the mind of the court, okay, the law says it must be resolved in favor of the accused person or the defendant, okay? And so when I prefer a charge sheet before the court, it is expected that I have the inculpatory evidence. The inculpatory evidence to inculpate the defendant and to hold him to account to that charge with evidence. Okay, so when we prosecution must be evidence-based and it must drive the point, must be unequivocal to the point that the prosecution is able to secure
Evans, sorry,
the conviction.
Evans, sorry, thank you for that. But again, I don't necessarily, let me just say, do not understand. So, you know, I'll make an example. If there's a murder case, one of the greatest evidence is the murder weapon, right? So I'm just trying to understand that in cases like this, what evidence should be brought forward that puts us in a position where we know, even if the jury is there, enough evidence substantiates the fact that beyond reasonable doubt, this is a shut case. Are we looking at bank statements? Are we looking at proof of purchases? Can you just give us a guide as to perhaps this is what is needed?
I've said it before now. You said that he owned properties that he never declared, okay? That he owned this property, he didn't declare them, okay? Or that he underdeclared, okay, and he owned them. So, which is an offense for a public servant, okay? Now, the onus is on you to prove that he owned those properties. You have to show how he acquired those properties by deed of assignment, or by a deed of gift, or by a receipt of purchase, okay? Whatever it is that is required in the acquisition of landed or real estate, those evidence have to be before the court, and they have to show that truly the defendant actually owned those properties. He bought them at so time. He never declared them, or he underdeclared them, and all that. Okay, the ownership has to be established, and that's to be established based on evidence. So in the event that that was not, the prosecution didn't have all that. They were just banking on the bandwagon that he committed the said offenses. It has to be proven, because if there's no evidence and then the court goes ahead to convict on the basis of mere allegations, what it means is that at the end of the day, everyone will be touched by that saw, because Tomorrow it might be the other, it might twist the other way around.
Okay.
And
Evans,
then we'll be asking that, the court acts without evidence.
Evans
There
Ufeli,
must be evidence.
Evans Ufeli, so we've been seeing plenty of these high-profile corruption cases take the same pattern, where we would often hear that, hey, prosecution failed or this or that, and then they've been discharged and acquitted. I'm wondering whether this is pointing to one of three things, which could be in maybe weak investigation by the NDLEA or poor documentation, or is our legal system just totally skewed to let these individuals these high-profile individuals in corruption cases just go free? What's your personal opinion?
No, what our law enforcement agencies do is that they rush into prosecution. They don't conclude their investigation. In fact, the moment an allegation is made, they arrest immediately. It is after they arrest and put the suspect in detention that they now go and start to scramble for evidence. And that's a very wrong way to start, because criminal prosecution starts from investigation. Okay? You need to get all your evidence. You need to get all the documents and evidence you need before you can even initiate a process in court. If you're investigating someone of an offense and you are not able to get the requisite evidence that you require for prosecution, you don't have to prosecute. Mm-hmm. Let the person get an administrative bail and go until you're able to get enough evidence against him. Okay. Otherwise, you run into and that is what they do most times. The EFCC do the same thing, the police do the same thing, the NDLEA, all our law enforcement agencies. They are very quick to go to the press to make a press statement, yes. And make allegations. But when it comes to proving the said allegations in court, sometimes, most times, they fall short of the requirements.
Evans, some of these proofs, some of the proof that was presented in court also included his brothers disguising properties as their own and also swearing in false affidavits. But the judge actually, what was it the judge said? The judge reportedly questioned the basis of the conspiracy allegation here. So if these were presented by the NDLEA, how much liberty does the judge actually have when he says, nah, that doesn't matter, it's not related, these people cannot be, they can't be, I don't know what the legal term is, but apparently he thought that that was not enough evidence.
Yeah, during trial, the judge is not just undertaking the case, he's looking at the demeanor of the persons involved, the case presented. During examination in chief, cross-examination, you see, the truth is revealed. Okay, if truly there was conspiracy to commit an offense, or they actually conspired to do all what, that would have been revealed during trial. Okay, but that the prosecution is unable to convince the court or to back the said charge and claim with evidence shows that they are unable to prove their case. The court is blind to the issues of all parties. What the court wants to see is that you say A took this or A did this, which is against this law. Okay, then you have to present everything that points to the fact that you actually did it, that you actually conspired. Okay. If in the course of doing that you're unable to prove it, you don't expect the court.
So Evans, to be clear, Evans, to be clear, what is the court saying regarding this conspiracy, the criticism of this conspiracy here by prosecution? Is it saying that they overreached when they involved his brothers?
It's saying that the prosecution is unable to establish even conspiracy itself. Okay? You see, conspiracy to commit an offense is an inchoate issue. Okay. Now, when you are conspiring to commit an offense and you are caught midway, okay, that you have not committed the offense here, you are caught midway, or you conspired and actually committed the offense. They are both on the same class. But what the judge is saying is that this conspiracy alleged hadn't even been proven. Okay? Because the said property upon which you base that conspiracy on, okay, you are not even able to prove it, that this was a property that was underdeclared, or this was a property that belongs to the said defendant and the rest of that, because the root, okay, of the establishment of the guilt of the defendant was lacking. It therefore falls to the ground, okay, that the prosecution was unable to prove any of the count charge. If the prosecution was able to prove conspiracy, the defendant would have been held to that, okay, and conviction would have been strictly based on that. But because there was no proof to that effect, the court will have no choice other than to resolve the case in favor of the defendant. And that's exactly what the court have done.
Okay.
Now, Evans, in many high-profile cases like this, and I would also use, Madueke's case as an example. In many high-profile corruption and financial crime cases, Nigerians often hear terms like, or hear the prosecution say things like, failed to prove its case. Is this a recurring, problem of weak investigations or poor documentation or even legal technicalities?
Yeah, that's what I said before now, that over there in the West, the reason they secure conviction in high-profile cases like this is because they conclude investigation before commencing trial, before they prefer charge. In our own case, we don't conclude investigation. Sometimes investigations are done haphazardly, or they are not concluded before prosecution starts. Okay, but because of that rush, the prosecution loses out a lot of details. And those details are details that are required in trial, okay? So when they're not able to put everything together and they rush to court, a smart defense counsel will rely on that loophole to deflect whatever the prosecution have built, okay? And once that is deflected and the prosecution is unable to hold on to itself, so all the defense counsel needs is a no-case submission, in that no-case submission, they will find out and then during cross-examination, water down the case of the prosecution, destroy the evidence of the prosecution to a point where no reasonable court can rely on the evidence of the prosecution to convict the defendants. Okay. When the defense counsel have done that, then it will leave it to the court to then look at what the prosecution has presented.
Okay,
whether
Evans,
any reasonable court can act on it.
Evans, we're almost out of time.
That's what happened in this case.
Evans, we're almost out of time, so we'd like to know exactly what happens next here in the case. We do know that there's another case that he is still that's still ongoing currently involving the NDLEA and I think a drug syndicate. So what happens next now? How does it affect the other case?
Yeah, it does not affect the other case in any way. This particular case, the prosecution still have options of appeal, okay? This is just the court of first instance, so they still have the court of appeal and they still have the Supreme Court. If they so wish to go further, they can go further and see how far that can go.
All right.
But as for the drug case, that one is still ongoing. It is still on. They will, of course, present their evidence before the court. And then the court will take a decision on it once trial is concluded. Evans,
thank you very much. Unfortunately, we can't go further than here because we have used up our allotted time for this segment. But thank you very much for bringing your legal mind so that we can understand this case. We continue to look forward and see where the other case will go, or maybe even if this would be appealed, perhaps. But we would always be glad to have you here with us on Breakfast Extra. Thank you.